Please, Lordship.
Yes,
Lordship, item number 7 then.
7.
Yeah, I'm under instruction to mention on behalf 7 then, 1-7.
1-7.
Yes.
Yeah.
So,
I'm appearing from this side, my lord.
Okay, Mr. Advocate.
My lord, in this matter, we were supposed to file the affidavit. We have sent the affidavit for verification with certain queries because certain notifications are not too clear about it. So we'll get that within a couple of weeks or so. Then we will file it. I would only request your lordship to keep it after June, after we have the vacation, anytime in July, subject to your lordship's convenience.
Anyways, Mr. Jomi, you are already having an interim.
Yes, sir.
Interim means there is an
Well,
given undertaking
that's all right,
by
Lord.
the Advocate General.
That's all right. There is an IA in the case which I filed recently, my lord.
Ah.
The Kachari tribe, they want to withdraw from the petition. I filed the IA.
But I had mentioned last time also that they had approached the government.
So then we take up the IA and close that IA insofar as the Kachari tribe is concerned.
Very well, very well.
So we pick it up after some time and.
Very well, we'll do that.
Okay.
We'll wait for it.
Lordship, item number 8. Lordship, sorry. I have a meeting at the secretary today. So this matter will be passed over for tomorrow. Item number 8. Item number 8.
8. What do you say, Mr. Takamatsu?
Tomorrow it's okay, Lordship. If he's praying for Passover, it's okay, Lordship, because I need to. In fact, after the government of India, Union of India filed an affidavit, there is a positive development. I am seeing some light at the end of the tunnel. We can dispose it of tomorrow, Lordship. We
At
all
the request of Mr. Intim Song, the learned edition and Advocate General, the matter stands adjourned to be taken up tomorrow.
pledge, Lordship. Sorry.
Yes, Mr. Ingo.
Question item number 8, 18, Lordship, sorry.
Yes.
I'm not 18. Heading item number 2, Lordship. I'm sorry, I did not bring my,
This is matter pertaining to what? Termination.
Lordship.
Termination.
Yes, Lordship.
So 2022.
Tomorrow, Lordship, I don't have the brief today, but I have some problem today, so.
Take my brief.
Tomorrow.
Half brief I have. Take my brief.
Item 18, Lordship, please.
Take my brief.
The other party is also not, Lordship.
Mr. There in the meeting.
Lordship, I'm not feeling, what I mean to say, Lordship,
Mr. Inti Longsha
Lordship.
always is there in the evening.
Lordship, I'm not feeling a bit well today, so
Okay.
it may be tomorrow. I'm not asking for the other, just a tournament, Lordship.
Item number 18.
Yes, Lordship.
Request of Mr. Gauhati, matters standard June to be taken up tomorrow.
Tomorrow, Lordship, please.
Please, my lord.
Yeah, I have only 18 matters.
Yes, I will just permitted to move an unlisted.
What is the unlisted about?
Lordship, despite similarly situated being invited to sit for suitability test, which is to be conducted till tomorrow, till day after tomorrow. Only till 27th, suitability test is to be conducted only till 27th of this month. Today is already 25th. There are more than 70 of us, but the present writ petitioners, 2 of them, they were not invited to sit for the suitability test. The issue raised here is well covered by the judgment and order dated 23/10/2025, passed in WBC 77 of 2024. Deeply obliged, Your Honor.
For admission, item number 1.
Your Lordship, your affidavit has been sent for vetting, Your Lordship. So if this can come up after a week.
The whole matter. You will require an affidavit. What affidavit? Please see my order of 17/3/2026. The instant writ petition was filed initially on so-and-so by 106 writ petitioners, claiming their right to be regularized in terms with the office memorandum dated so-and-so. His Assignment, the learned counsel appearing submits that in the meantime, 81 writ petitioners have already been regularized. This aspect is apparent from the fact that the petitioners also admit the same, as will be apparent from the amended writ petition which has been filed, where now presently there are only 26 writ petitioners. Mr. Ami, appearing on behalf of the state respondent, further submit that in the meantime the steps are being taken to consider the case of the petitioners for regularization in terms with the office memorandum dated 17/3/2015. However, in respect to respondent petition number 7 and 8, no steps can be taken for consideration of their case for regularization, as they have not provided the code number which is issued to each work charge employee. Ms. So-and-so, the learned counsel appearing on behalf, submits that within 7 days the code number will be provided. Have we provided?
Yours.
Then update. What is the update?
Your Lordship, here,
Why do we require an affidavit?
Your Lordship, here petitioner 9, 10 and 11, they have been regularized. And petitioner number 1, 2, 3, 4, 5, 6, 7, 8, 12, 13, 14, 15, 16, 17, 18, 19, 25 and 26, their cases have been, the finance department has given its concurrence.
No,
And-
therefore, you don't require to file an affidavit. You give an update after 1 month.
Okay.
Is the better thing,
Yes,
don't you
Lordship.
think? Why you are filing an affidavit? You give the list now who has become. How many have become out of 26 now?
Your Lordship,
9 and 11.
9, 10 and 11 has been regularized.
So out of 26, now 9, petitioner number 9, 10 and, madam, you just put it down. Madam, just put it down. 9, 10 and 11 regularized.
Yes, Your Lordship.
And who are under consideration?
Respondent number 1, 2, 3.
No, the petitioner.
A petitioner. Petitioner number 1, 2, 3, 4, 5, 6, 7, 8, 12, 13, 14, 15, 16, 17, 18, 19, 25 and 26. Their concurrence has been obtained.
Their finance department has given an approval.
Yes, Your Lordship. And as for
And what against whom are remaining?
petitioner number 20, 21, 22, 23 and 24.
They are remaining.
Yes, Your Lordship. Their cases have been resubmitted to the finance because certain verification was required.
Ms. A. I mean, the learned government advocate submits that in the meantime, so-and-so, the petitioner number so-and-so have already been regularized in terms with the office memorandum dated 17/3/2015. Insofar as the petitioner numbers, now the long list of petitions. The learned government advocate submits that the finance department has already given the approval and certain formalities are required to regularize the services of these petitioners. In addition to that, the learned government advocate submits that in respect to these petition number, the last list. The proposals have been resubmitted and an update would be provided on the next date. list this matter again on 24th of June 23rd of June 2026 for an update.
For admission, item numbers 2 to 4.
I may be permitted to withdraw this group of petitions, items 2 to 4, with liberty to approach appropriate court.
Whatever has a
Lordship, the negotiation,
claiming non-payment.
yes, it has failed with the state government. The amount is actually to be paid by the, it seems, it appears, by this union government. Now, off the record, this is off the record, the state government.
Mr. Sentient,
Yes,
nowadays when you are there in video conferencing, not in video conferencing, in this live streaming mode,
yes,
there's
my
no
lord.
off the record.
Yes, my lord, my lord.
Huh? Is
Yes,
there any
my-
off the record?
Yes.
Earlier, Mr. Mohammed, we could think about saying something off the record.
Yes, my
But
lord.
nowadays you can't say it is always online.
Yes, my lord.
Okay, now what do you want?
I may
You
be
want to
permitted-
withdraw, I know that.
Yes.
Now, these are matters pertaining for claiming of certain amounts.
My lord.
Okay. Now, if you don't give me a good reason, I can't give you the benefit of limitation.
My lord.
You have filed these in the year 2024.
Yes, my lord.
So the period of filing of these petitions should be, these limitations should be taken away.
Yes, my lord.
Otherwise, if you go to the civil court, you will have a problem,
Yes, my lord. My lord.
isn't it?
My lord. My
Now,
lord.
give
I
me a
agree.
good reason why.
Now, my lord, the state government, they are most willing to cooperate with and they understand my grievance also. But the union who are supposed to actually release the amount for paying me, they are not very responsive, not cooperative till then, which is why
Union,
yes, yes.
which union?
Union of India?
Union of India is not cooperating.
Yes, my lord. Because the project is only.
So
funded-
you have not made the union a party.
No, my lord. No, my lord.
So
Because
therefore you
since-
want to withdraw
Yes,
with liberty to refile.
yes, my lord. Not before this honorable court, but before the civil court, my lord. I
Before the
want- yes,
civil
yes,
court.
my lord.
Okay. Heard Mr. These will be three separate orders, huh? Heard Mr. Santianga, the learned counsel appearing on behalf of the petitioner. Mr. Mohamchin appears on behalf of all the respondents. The instant writ petition has been filed by the petitioner claiming an amount of rupees 34,24,114. Which the petitioner is entitled for carrying out the work pertaining to construction of multipurpose hall at Jakphang. Mr. Santianga, learned counsel appearing on behalf of the petitioner submits that the work which was awarded to the petitioner was on the basis of a centrally sponsored scheme funded by the Ministry of Tourism, Government of India, as would be apparent from the affidavit in opposition filed by the respondent number 126. And therefore, without the respondent, without the Ministry of Tourism, Government of India, having made a party, the petitioner cannot claim the due, would not be entitled to the relief as has been sought for. The learned counsel for the petitioner further submitted that based on this centrally sponsored scheme, the petitioner was issued a work order. And therefore, the doctrine of promissory estoppel as well as the principles of legitimate expectation are involved. However, these have not been mentioned these pleas have not been taken in the writ petition, and thereby leading to a formal defect. He therefore submits that the petitioner would be well advised to withdraw the instant writ petition and again either refile before this court or approach the competent authority,
My lord.
competent court. Taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to again approach this court by removing the formal defects by including the principles of legitimate expectation as well as the doctrine of promissory estoppel. In addition to that, liberty is also given to the petitioner to approach the appropriate forum, civil court, if so advised. Taking into account that in the meantime, that the petitioner have been diligently pursuing the instant proceedings under a bona fide belief that the amount to which the petitioner was claiming was an amount which could be paid by the state respondents. It is the opinion of this court that the period during which the instant writ petition has been pending before this court, that is, with effect from 8th of March 2024 till date, be excluded while computing the period of limitation. But you have a good case by filing this. That is why I inserted that.
Yes, my lord, my lord.
You come up with the principles of estoppel.
No, no.
Other two writ petitions also, just check. Mr. Santianger, help
My lord, my lord,
and give the amount and the work.
my lord. Deeply obliged.
For admission, item number 5.
2, 3, and 4, madam, they will be disposed of in this manner. Mr. Santianger will provide the details properly, and if he does not provide, don't sign, don't, okay?
May I please, Your Lordship?
Yes.
My lord, I'm mentioning on behalf of Mosam Sah, the counsel for the state, my lord. My lord, he is in Pirifpin, my lord. So he requested Your Lordship to list the matter on trustee, my lord.
Let me
Yes.
look into it. What is the case about?
I'm praying for.
Challenging the order of appointment of grade 4 post of respondent number 6 and the appointment order issued by the authority. The petitioner's uncle donated air construction of according his father was appointed to grade 4 of Chokidar India. Upon his release, the petitioner's name was also recommended for the year. However, the respondent number 6 was appointed to the year. What case you have?
On land ownership basis.
Land ownership.
Lord,
Land ownership cannot be in perpetuity.
no, sure, Lord.
Isn't that the mandate? Land ownership cannot be in perpetuity. You have,
But till
your
today-
father has already been appointed as a chokidar.
It was on general category, Lord.
No, this is
Yes,
what has
Lord.
been recorded in the order of 29/5/2025. Here it says, it is submitted that the petitioner's uncle, family members donated the land measuring 62,000 for construction of a government high school. Accordingly, his father was appointed to the grade 4 post of Chokidar in the said school. Let us see what you have mentioned. Or not on land ownership basis. The court has wrongly written. Anyways, so
My lord, let the matter come up on trustee, my lord.
who is appearing for the other side? Respondent? State?
State, yes, Mosam Sah, counsel for the state.
You are not appearing?
Yes, my lord.
Thursday is closed. That is why you are asking. Huh?
No, my lord.
Yes, Thursday has been declared to be a holiday. Wednesday is the working day. You are not aware?
Then, my lord, then Monday, Friday,
Yeah.
my lord, Friday.
Now tell it on Saturday.
Friday, my lord.
Friday? Hello? At the request of Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, respondents, the matter stands adjourned to be listed on Friday. So no further adjournment shall be done.
Obliged. Much obliged.
For admission, item number 6.
Not this, your lordship. Lordship, here I'm preparing my affidavit, so kindly grant me 3 weeks to file my affidavit.
2005 Met, 25 Met.
Lordship,
One year.
verification have been done repeatedly, and I have received a verification report, Lordship.
Verification for compassionate appointment. You got it.
No, the about the land
This is for what?
Ownership.
ownership, Lordship.
Land ownership.
Lordship,
Verification has been done.
Lordship.
Where?
Changdungya, Mogutung district, Lord.
And he's not entitled to.
Lordship, they are genuine. Yes, they are genuine land ownership. They are the owner.
Genuine.
Yes, Lordship.
Then why haven't you given? And what is he asking for? To appoint the petitioner on land ownership basis against the vacancy caused by so and so. Okay, now if you have found it that he is genuine,
Lordship,
we dispose it of thereby considering on the basis of verification his case.
My lord.
Matter over.
Lordship.
Why do we require you to file an affidavit spoiling environmental degradation? Okay. No. This can't help. You have this verification has not been done by the district commissioner.
No, Lordship.
What?
They've been endorsed by through this.
No, they can't do it. I think as per 3B
My lord. Yes.
of that 5/3/2018.
Yes, my lord. My lord.
It is the deputy commissioner who is.
Yes, my lord.
Then the verification has not been done. Now, has the deputy commissioner looked into this aspect or not?
Lordship.
You know,
Through,
Huh? Has the deputy commissioner done it as per 3B? When there is a claim being made,
Lordship.
it is the deputy commissioner who has to do it as to whether it is done, whether he is entitled or not, as per land ownership.
Lordship.
Without that, nobody can be appointed. Have you done that?
It's done by the civil STO, Lordship. What
Where?
I've received.
Now, that document is written by some customary code to the civil SDO.
Yes, verification.
I'm asking you whether the civil SDO has done it. Because this post is otherwise lying vacant.
Yes.
Lordship, this is done by the civil STO.
Ah. Okay. Show me the other paper. She gave it. So on the basis of this, we dispose it of.
Lordship.
Heard Mr. Santiago, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so, who appears on behalf of the respondent numbers 1 to 6. The present petition has been filed by the petitioner, seeking a direction upon the respondent authorities to appoint the petitioner on land ownership basis against the vacancy caused by the retirement of Srimati Wati Sangla, Chokidar, PWD, bracket RNB, Changtongya Division, Mokoksong, Nagaland. Next. The brief facts which have led to the filing of the present writ petition are that the petitioner claims that her father, late Purnuklu, along with several others, donated a plot of land on which the Chantongya office and the central store of PWD RNB subdivision, Chantongya, was established. The said land was jointly and severally donated to the department on the verbal assurance given by the department that appointment to grade 4 posts shall be made given to the landowners as and when the vacancy arises. The petitioner have enclosed a certificate issued by the Chantongya Village Council, issued by the chairman of the Chantongya Village Council, whereby it is mentioned that the petitioner's father had donated the land and the Chantongya Village Council was pleased to recommend the petitioner to be appointed into the vacant post vacated due to superannuation of one Srimati Wati Sangla Chokidar. The petitioner also had submitted an application for being considered for appointment on the basis of the landowners, on the basis of the policy of the government of Nagaland pertaining to land ownership. The application of the petitioner was also forwarded by the chief engineer NPWD Nagaland, by the engineer in chief NPWD Nagaland, by the communication dated 18/9/2024. In spite of that, as the case of the petitioner was not considered, the petitioner had been compelled to approach this court by filing the present petition. The record reveals that this court, by an order dated 12/6/2025, issued notice. No affidavit thereupon have been filed by the respondents, in spite of various adjournments having been sought for. Today, when the matter has been taken up, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, our respondents submitted that certain verifications have been carried out. In that regard, he has placed before the court the communication issued by the subdivisional officer civil dated 24/7/2025 to the Deputy Commissioner Mokoksong, wherein a communication issued by the head DB of the customary court Changtongya, Nagaland, dated 5/7/2025 was enclosed. All these communications, the said communication dated 24/7/2025, along with its enclosures, are collectively kept on record and marked with the letter X. Mr. Put a staple, huh? From a perusal of the above communication, the documents which have been kept on record, so this court have duly heard the learned counsels appearing on behalf of the parties. From the perusal of the at this stage, this court, heard the materials on record show that the state of Nagaland has a land policy, has a policy for granting appointment on land ownership basis. First, this policy is mentioned in the office memorandum dated 16/4/2018. Clauses 3A and 3B being relevant are reproduced hereunder. Madam, you'll get these quoted clauses at page number 9 of the reproduction. Oh, it is here, annexure 9. Wait. You have not enclosed the entire thing, Mr. Counsel. What have you enclosed?
My lord.
You have not enclosed it. What is annexure 9? What you write in your petition is different from what is the enclosure. Are you the counsel for the petitioner?
Yes, my lord.
See, what is annexure 9? You have a copy of the petition?
No, my lord.
Why?
I forgot to bring it, lord.
Cut off everything. I'm ready. Mr. Santinga, the learned counsel appearing on behalf of the petitioner submits that he does not have the brief. It seems that the counsel appearing on the petitioner have not taken up the matter seriously. List the matter. The registry shall list the matter only upon application being filed by the counsel before the registry that he is seriously and genuinely interested in pursuing with the petitioner.
Yes, my lord.
For admission, item number 7.
Here, lordship, the state respondents, they have conducted the verification, which is annexed at page 13 of the state's affidavit, my lord.
Please, Lordship. Lordship, I'm for the respondent number 7 here. Lordship, I filed my Vakalanama this morning only.
Okay, the respondent number 7 is represented by so and so, who submits that he has filed his Wakalatnama today. First up, the counsel submits that he requires 4 weeks time.
1 week, Lordship.
Is there a stay?
No, my lord.
There is no stay. Oh, there is a stay. We vacate the stay.
Lordship.
Okay.
Lordship.
In the meantime, you go ahead and proceed with the appointment of the respondent number 7.
Lordship, the interim may kindly be extended.
You don't have the file.
No, I have, lordship. This
So you have
I did
to
not.
choose cases wherein you are having a file, wherein you are not having a file.
Lordship,
Sorry,
actually, I have.
I am not there. Anyways,
Lordship,
I am not extending the
read-
interim order.
I have read.
4 weeks' time is granted to the
Item
learned
number two,
counsel
sir,
appearing on behalf of the respondent number 7 to file an affidavit in opposition. List the matter.
Lordship, right.
Lordship, the interim may kindly be extended.
No,
Lordship.
I am not extending it on behalf of a
Obliged, my
counsel
lord.
who does not bring the file.
For admission, item number 9.
Your Lordship, here I have filed my affidavit this morning, Your Lordship.
You file?
Yes, Your Lordship.
Judges.
You want to file reply?
Lordship, the matter may come after a week, Lordship.
What, huh?
I meant to go through and visit the copy just now.
Okay, Ms. A. Ami, the learned counsel appearing on behalf of the petitioners, respondent submits that an affidavit in opposition have been filed on behalf of the state. Mr. So-and-so appearing on behalf of the petitioner submits that he has just received a copy and would consult with his client or consult with the petitioner as to whether they would like to file a reply. Accordingly, list this matter on 15th of June. In the meantime, the petitioner would be at liberty to file the reply.
For admission, item number 10.
Yes, Mr. Joe.
My please, Your Lordship, I'm for the respondent number 4, private respondent. We're yet to receive some documents, so kindly grant us some time to file affidavit in opposition.
Affidavit in opposition.
Yes, Your Lordship.
You have no objection? No objection. Ms. So-and-so, who appears on behalf of the respondent number 4,
Yes.
submits that she would like to take, if the respondent number 4 would like to file an affidavit in opposition. Taking into account the above, 4 weeks. 4 weeks' time is granted to the respondents number 4 to file the affidavit in opposition. List this matter again on 25th of June 2026. In the meantime, the affidavit in opposition will be filed on behalf of the respondent number 4.
Your Lordship, my senior name is not reflected in the call slate, so kindly let it be reflected.
And put it, you ask the registry.
For admission, item number 11.
May I please, Your Lordship? Lordship, on behalf of aspirant, the state is here to receive instruction. So kindly grant 3 weeks time to file affidavit.
Hmm? You want to?
The state is here to receive instruction, Lordship.
You want to file a reply, affidavit in opposition?
Affidavit in opposition, Lordship.
Ms. So-and-so appearing on behalf of the petitioners, a respondent submits that the state would like to file an affidavit in opposition, and the same would be filed within a period of 4 weeks.
Lordship.
List this matter again on 25th of June 2026. In the meantime, the affidavit in opposition be filed on behalf of the state.
For orders, item number 12.
May I please, Lordship? Lordship, here, I'm appearing on behalf of opposite party, number 1.
IA for
For recall of order.
nullify the order passed by this court which was obtained by playing fraud. Playing fraud? They file your reply.
Lordship. No.
What fraud they have played? You are the petitioner. Who is
Lordship.
the IA? Who has filed the IA?
They're fine.
Lordship, this IA is to nullify the order dated 29/11/2022, passed in WPC 2021 of
Where?
2019.
Where's the page? 29?
29/11/2022.
Ah. Oh, what happened this order?
Lordship, the order is at page 93, annexure H.
Okay, so it was on the question of death of the husband.
Lordship.
Okay, then what do you have to say?
Lordship, if I may read para 4, page 8.
Just 1 minute. Huh? Page?
Page 8, para 4.
Yes.
That the applicants beg to state that the petitioner in WPC number 139 of 2024 has made a categorical statement that the petitioner was filed on behalf of Master Benutang Nguli, who is the minor son of late Munglumo, who is of 16 years of age. Since some discrepancies were detected regarding the age of the petitioner in WPC number 139 of 2024, an inquiry was initiated to ascertain the.
What is your basis to come to a year that he died on 10/7/2011?
Lordship, can you see Annexure L?
Huh?
Annexure L.
Annexure L, page? Page?
Page 111.
Huh?
111. Annexure M, page 112.
Submission of report by IC Legal Branch Kohima. Compliance to the year date itself is when attached to the legal branch Kohima preceded. So the release on. So we can go into that. These are different person. Name is different. This person is some Nugli, whereas here the person is Lotha. Huh? Same.
Lordship, I may be given 3 weeks' time to file my option.
It's okay, but my question is here, is this both the persons
As per
same?
the statement, both of us of same person.
Huh?
Same person.
Same person,
Yeah, that's what in their petition.
they say.
Yeah.
Do you say so?
Let me. I'm yet to go through.
In fact, this is an application file for recalling the order,
Lordship,
recalling my order. So it is I who have to take it. Nobody else can take it up. Isn't it? No person can otherwise take it. No. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Applicant. Applicants. And Mr. So-and-so who appears on behalf of the opposite party. Number 1. This is an application filed for recall of the judgment and order dated 29/11/2022, passed in WPC number 221/2019 by this court on the ground that a fraud was played upon this court by the opposite party number one, who was the petitioner, by informing this court that her husband expired on 28/1/2008. Ms. So-and-so, the learned counsel appearing on behalf of the applicant, submitted that it was solely on the basis that the husband of the petitioner, the opposite party number one, having expired on 28/1/2008, and thereupon the disciplinary proceedings were culminated, whereby the husband of the petitioner was dismissed from service. This court had interfered with the disciplinary proceedings as well as the orders passed therein, as well as the punishments so imposed. The learned counsel further submitted that pursuant to the judgment passed by this court on 29/11/2025, an inquiry was conducted in the village of the opposite party number one. Upon inquiry, so conducted by the in-charge legal branch PHQ, Kohima, it came to light that the husband of the opposite party number one expired on 10/7/2011, which would be apparent from the certificate of death issued by the Saki Baptist Church, as well as the, what do you call that, the stone? The memorial stone over the grave of the husband of the opposite party number one, wherein also it is inscribed that the husband of the opposite party number one expired on 10/7/2011. The learned counsel further submitted that the secretary, Saki Baptist Church, has also issued a certificate on 1/7/2025 certifying that late Thung So Nugle and Mong Lungmo Nugle are the same person, is the same person. The learned counsel appearing on behalf of the opposite party number one submits that she would like to file an affidavit as regards the statements so made in the instant application. Taking into account the above, list this matter again on 23rd of June 2026. In the meantime, the opposite party number one is directed to file the affidavit in opposition and reply to the interlocutory application filed without fail on or before 22nd of June 2026. As the order pertains to an order passed by this court, the recalling application has to be considered by this court, and therefore the registry shall place the matter before this court, either list code. Pusto. Will come only before me, can't go before any of you. And Mr. Counsel, if it is a fraud, then obviously it's a very serious action.
No.
There's a state with that order, no directions. What was the direction passed? Pusto. Taking into account the serious allegations so made in the instant application, the order dated 29/11/2022 in WPC number 221/2019 shall remain stayed.
Oblige.
For orders, item number 13.
Thank you, Your Lordship.
Who has decided land disputes?
Lordship here, firstly, DB's court Shamator. Then again, an appeal was made before the DC. And then again, an order was passed by two of his subordinate officers in the name of DC. Lordship.
The DB decided how? Because the rule says that either you have to file an application
Lordship.
and the DC will refer, the
Yes.
ADC will refer
Yes,
to the Dobasi court.
Lordship,
Thereupon the Dobasi court shall decide.
Lordship.
An appeal thereagainst lies before the deputy commissioner. Now it will lie before the district judge,
Lordship,
isn't it?
Lordship.
Why should we entertain this type of petition matter? Mr. Angami,
Lordship, yes.
why the matter has come up?
Lordship, now there are
Service is complete.
Lordship, service upon respondent 3 and 4 are still awaited.
Huh?
Service upon respondent.
Service is complete now. We'll take it as the service is complete. So therefore, now the question is, we take it up on the above, on the next date. As to, you are to satisfy this court next week as to how the instant petition would be maintainable. Taking into account that an appeal lies before the district judge now,
Lordship,
isn't it?
Lordship.
Lie before the district judge, an
Yes.
appeal under 31.
Yes, Lordship, one thing they're aggrieved by is their contention is that initially a judgment was pending before the village, Sampur Village Council Authority. Then before passing the judgment, so since the judgment was not passed, they have approached DC with a representation. Then DC, instead of disposing the representation, he has endorsed the case with DB, which should not be according to them.
But they went and participated in the.
Yes, yes, of course.
Then?
Yes.
Oh. Okay. This court have duly taken note of the office note dated 21/5/2026. Accordingly, the service is complete. List this matter again on 1st of June 2026. On which date the learned counsel appearing on for admission on 1st of June 2026. On which date the learned counsel appearing on behalf of the petitioners shall explain as to how the instant proceedings is maintainable, taking into account that there is an alternative and efficacious remedy under 32, na? 32 or 31?
31.
Under 31 of the rules. What is the rules?
Nagaland, administration of Nagaland.
Rules for administration of justice and police in Nagaland. 19.
In Nila Kitab.
Lordship, there's an interim. There's an interim.
1st of June.
For orders, item number 14.
I don't have find the affidavit of service from so respondent.
May I please, Your Lordship? I've received instruction to appear on behalf of the respondent.
For whom?
Respondent, sole respondent. Kindly grant me some time to file my bakalatnama.
What order has been passed by the principal district judge, Mr. Jigami?
Upholding the order of temporary injunction by the trial court.
So how is a writ petition maintainable under 226?
Under 227, my lord. Not
This
226.
227 it should have been registered as a civil revision.
Your Lordship, according to the instructions issued by the registry, the High Court, both 226 and 227 petitions.
No. There's a High Court categorical thing which is being mentioned. 227 has to be registered as a civil revision petition. And CRP IO. And one which comes under 115,
My lord.
it is registered as CRP, Civil Revision Petition.
Is there a new set of instructions, my lord?
That is the rule.
Otherwise,
It can't be under 227, it cannot be registered as a writ petition. Because what happens? Against this, there is no appeal.
my lord,
227, there is no appeal.
my lord.
So therefore, if you are registering it as a writ petition, a appeal will lie. It will be a writ petition,
My lord.
writ appeal. So it can't be a writ petition.
According to the High Court rules, my lord. The High Court notifications.
Therefore, in the principal seat, we have this, it's make it very clear.
My lord,
Unless
otherwise,
for the state, for the area of Nagaland, it's a different thing. This is an old book. Where is that from? See here, page 465. Here also it is old, so now you, in principal seat, it is given very clear. 465.
yes, my lord.
Civil revision under Article 227 of the Constitution. 465.
Is the notification dated October 2018, my lord?
18.
Yes, ma'am.
Does it say CRPIO? No, I think that
no, my
this
lord.
is later. There's a later on another one. No, can we see? Therefore, you see 465.
465.
It's an old one. How things have changed. No CIS, when they are maintaining with the CIS, they have to have it. Very good. 465. Take this book if you don't have it. But after this also there is a change.
Under Article 227.
After this also, Mr. Jimoma, there is a change to effect. Now,
My lord.
227 will be CRPIO. Civil Revision Petition, bracket interlocutory order.
My lord.
And 115, if you come, it is Civil Revision Petition.
My lord.
It is only against the tribunals a writ will lie.
My lord.
So it can't be a registered as a writ petition. In fact, the entire CIS system would be wrong. So we direct them to register it as a CRPI. There's no problem with that. It is, you have filed
In fact-
rightly under
fact,
227.
If your lordship will see page 471. Page 471.
Yes.
WBC may not, serial number 111. Writ petition under 226 and 227.
No, this is appendix 33, you see. List of case types old and new.
Yes, my lord.
Heading. So it was earlier like this. Now the change is this. Now just for example, I tell you.
Yes, my lord.
Earlier, when we started practice, we had the code called 10189.
My lord.
10189 had all cases or any difficulty in understanding,
My lord.
you put 10189. Now you have different codes for each bench.
Yes.
In bench one, any other matter will come under a different. You don't put 10189. Because what happens, 10189 in the principal seat is belongs to bench 5 now.
My lord.
Whereas 101, and there's another code. So these have all changed in the meantime. But now the principal seat out there, it is absolutely clear that it is 227, it is under this, because there is a reason why. When an appeal is not provided, revision is not provided under 150, then if you go under 227, then it is a necessity to catch hold of and finish it off as early as possible.
Right.
Because these are against interlocutory orders. So therefore, an injunction being granted is an interlocutory order. So against that, you have to come under 227 only. Once you come under 227, it has to be under CRPIO. Then only it catches the eye.
Very
So
good.
therefore, we direct them to release this matter. And what do you want? You want to file affidavit? You
Yes,
don't file affidavit in CRPIO. You have produced the records, I suppose.
Yes, my lord.
No, you have produced the entire pleading.
Yes, my lord. The entire
So
period.
the pleadings are there. So therefore, where is the question of filing affidavit? We
Yeah.
have out here to consider as to whether the learned trial court or the first appellate court were
Yes, sir.
justified in granting the injunction or not. Nothing more than that. What
Yes,
is
sir.
there to file affidavit?
I'm yet to file my vakalatnama.
Don't file. You can very well participate out here, taking into account if you were there in the trial court. And if you have not filed a wakalatnama, you have no business out here to stand before this court.
I have received instruction to appear.
So then file your wakalatnama
Yes.
during the course of the day. Next week we finish it off. This matter can't go on. He is entitled to the injunction, good. If he is not entitled to the injunction, bad. Okay, next week. You are going to file the wakalatnama today.
Yes, Lordship.
Yes. This is an application filed under Article 227 of the Constitution, challenging the order dated 31/2026, passed by the learned Principal District and Session Judge Dimapur, Nagaland, in Civil Appeal number 2/2024, arising out of IAC number 88/2024 in title suit number 02/2024. From perusal of the impugned order, it is seen that it is an order passed by the First Appellate Court. The jurisdiction which is to be exercised in the instant proceedings is a supervisory jurisdiction of this court under Article 227 of the Constitution. Considering the above, this court have also taken note of that the instant application have been registered as a writ petition. However, it is the opinion of this court that the instant application ought to have been registered as a civil revision petition, bracket interlocutory order, bracket close. Ako আৰু এটা double bracket kori itu, CRPIO. The registry shall do the needful in that regard and relist this matter for admission on
Monday,
first
Monday.
Monday.
Your Lordship,
First of-
can you kindly grant me 2 weeks time, Your Lordship?
For what?
I have some unavoidable circumstances which I cannot avoid.
Don't
I-
appear. None appears, we will allow his petition. On 1st of June 2026. So and so, the interim order passed earlier shall continue till the next day.
Much better.
In the meantime, the counsel appearing on behalf of the opposite party submits that he would be filing his opposite, he would be, opposite party so and so would be filing his power on the next, by tomorrow, by today.
For orders,
Thank you.
item number 15.
May it please your lordship. I'm entering appearance for respondent number 3.
2 and 3?
2 is the post of vice chancellor is presently lying vacant. So I am entering appearance only in respect of respondent number 3, who is the registrar of the university.
So I think appearance of 2 is sufficient.
Yes, Your Honor. But two posts is lying vacant. Who is the vice chancellor?
Understood. Lying vacant, it's okay.
Yes.
But here, International University is a party, isn't it, Mr. Counsel?
Yes.
International University is a party.
Yes, Lordship.
Why have you filed a writ petition? Salary,
Yes, for non-payment of salary.
so non-payment of salary. But it is being duly represented. In fact, the International University normally is represented by the registrar.
Yes.
So it is not required to have the vice chancellor. Anyways, the post is vacant, but otherwise we can consider that the service is complete.
Yes, Your Honor.
This court had taken note of the office note dated 27/4/2026. In addition to that, Mr. So-and-so appears on behalf of the respondent number 3. It is duly submitted that the claim of the petitioner is against the International University for non-payment of the dues. The International University is represented by the registrar, who is the respondent number 3. Under such circumstances, the service is complete. List the matter. Under such circumstances, the service complete. Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 3, submits that he requires 4 weeks' time to file the affidavit in opposition. List the matter for admission on 25th of June 2026. In the meantime, the affidavit in opposition be filed on or before 23rd of June 2026 by the respondent number 3.
Highly obliged.
You don't have anything to do. You don't pay. Who pays?
Yet to file, lordship. The state also yet to file, lordship.
State also will file the affidavit in opposition on or before 23rd.
I pledge.
For orders, item number 16.
Please, Your Lordship, steps have been taken for upon respondent number 3 to 10 on 29th of February.
You are paying for?
For the state respondent number 1 and 2.
What is the matter about promotion?
Yes, promotion,
Respondent numbers
3 to 10.
3 to 10.
Yes, Your Lord.
Working under you.
My lord.
They are working under you.
Yes, my lord.
You do one thing. You serve extra copies to him. You will serve it through his office.
My lord, I've already communicated.
No, you communicate it to the director,
I've done.
social welfare.
Yes,
to whom
ma'am.
you are appearing. Give him the extra copies. He'll serve it to those people.
For this private respondent number 3 to
3 to
10.
10. They are working under you. They are working under the.
Yes, my
respondent
lord.
number-
Yes, my lord. Yes,
So
my lord.
therefore, she will give you extra copies for respondent number 3 to 10.
Yes, my lord.
You give it to the director.
Yes, ma'am.
And the director will effect service
Yes,
and
ma'am.
submit a report before this court that the service is done. Problem solved.
Okay. Yes, my lord. I know I feel it.
Lordship, I've served the service through speed post and usual process as well.
Huh?
I've taken steps through speed post.
You have
and
no
usual-
urgency?
I'll serve extra copies.
Better off, na? Then it will be, service will be complete. They can't say later on the service is not complete.
Lordship.
Okay? You're enjoying an interim order. Let the service be complete. Okay. God bless you. This court have taken note of the office note dated 30/4/2026. And from the office note, it is seen that the service is awaited against the respondent number 3 to 10. List this matter only upon service being completed. Now, list this matter again on 25th of June 2026 with an update as to whether the service upon the respondent number 3 to 10 is complete. Mr.
LD Sangha.
L.D. Sanktam, the learned additional advocate general appearing on behalf of the respondent number 1 and 2 submits that the state would be filing the affidavit in
Yes,
opposition.
ma'am. Yes.
First, list this matter again on 25/6/2026. Affidavit be in opposition be filed on or before 23/6/2026. The interim order passed earlier on 24/4/2026 stands extended till the next date.
Right.
Mr. Sanktam, there is an interim order. Why don't you ask those persons to appear? Better off.
Yes. Ma'am. For orders, item number 17.
This, Mr. Zimomi, this application is being wrongly made. To file another one, taking into account this application has to be filed only by the Kachari.
Okay.
Others cannot be a party to this because the moment the others become applicant, it becomes a problem because if they are, they cannot say that kindly remove him. So you refile it, withdraw and refile it.
I can do that.
Because you see, you then make only the applicant number 3
Madam.
or who is the petitioner number 3 as a party applicant.
Madam.
You don't make the others, the Kuki, the Garo as well as the Karbi. You don't make them. You want the Kachari to be out. No?
Yes, ma'am.
So only let the Kachari be the applicant.
Very well. I'll do that.
Okay. Mr. Ejimomi, the Learned Counsel appearing on behalf of the petitioner submits that there is a formal defect in the instant application. He therefore submits that he may be permitted to withdraw the instant application and file a fresh one. So taking into account the above, the instant application stands closed on withdrawal. First, the applicants, and more particularly the applicant number 3,
Madam.
is granted the liberty to file again.
Much better.
Mr. Advocate General, I have noted there is an apparent formal defect.
I have understood that, correct. It may go,
And the 4 cannot be an applicant.
it may go to my advantage later. Well, I just said that I wanted some time to file the affidavit in this matter, and the matter may be taken up.
That matter has not come up before us today.
No,
Only
this,
IA has come up.
okay, very good, very good.
We'll file it. And Mr. Jimomi, I would advise you don't appear for this applicant number 3. Ask somebody else to do it.
I can do that.
Because no, the problem is there's a conflict between you and the applicant number 3 now. Because 1, 2, and 4 still continue with a cause of action.
Right.
And you are representing them. And if you give up 1, then you are ask any junior to file that application.
Very well. Do that.
Lovely.
For unlisted motion, item number 22.
Yeah, my lord. Similarly situated employees. I have stated my entire facts in my synopsis.
Yes, Mr. Angami, what do you say?
Lordship, yes, as per the records available in the read, it appears that
Have you filed an appeal against the judgment passed by the?
no, Your Lordship. In fact, the steps are been taken by the department to comply with the order, as can be seen from the last page of this present writ petition, my lord.
Page 58.
Yes.
So here, these petitioners herein were not a part of that earlier batch.
No.
But here the decision was at this junction, the petitioner has strongly raised the prayer for reinstatement. It appears that the equity will prevail if the petitioners are allowed to take part in the suitability test as per the conditions in the appointment order. So therefore, the only thing is that petitioners herein who were similarly situated,
Yes.
they have not been provided with the benefit because they were not a part of the earlier.
Correct. They are not a part of that writ petition which has been disposed of, my lord.
So it would be in violation of Article 14 to only confer the benefit upon those petitioners and not to give the benefit to others who were also terminated.
Correct.
So therefore, we allow this petition.
Yes, Your Lordship.
Because there cannot be any interim order passed here.
No, yes, my lord. I agree with my lord.
So we allow this petition, thereby allowing them to participate in the suitability test, taking into account that these two petitioners are similarly situated with that of
Writ petitioners in there. Yes, Your Lordship. After making a verification, if they are found that they stand on the similar footing with that of the writ petitioners,
we take it up again at 12 o'clock, this matter.
Yes.
In the meantime, you just find it out as to whether it is similarly situated.
Lordship.
Just find it out, okay?
My
Because then I'll pass the final order.
Lordship.
I'll pass the final order now itself.
Yes.
So just find out instead of me reading the petition. You find it out as to whether the petitioners are similarly situated with that of the petitioners in the earlier.
Yes.
It is only because of they having not approached this court.
Correct.
Should they be barred? That is the only question.
Correct.
So therefore, have a look at it. Let me know by 12 o'clock.
Yes, my lord. Yes, my lord. The group PC number. '85 of 36.
Yes, Mr. Ahmed.
Yes, my lord. Lordship, I have taken the instruction. The only issue here, your lordship, if I may be allowed to make a short submission on this. Though, of course, your lordship, they are similarly situated, no doubt. But what happened is that your lordship, in this writ petition which has been disposed of and which the petitioners are claiming to be similarly situated here, lordship, on these writ petitioners, when they approached this honorable court, the interim was granted. Interim was granted to the extent that the post that was held by the petitioner at that point of time should not be filled up until unless the disposal of the writ petition. And therefore, that particular post that is numbering to 72 was kept vacant, your lordship. Now, your lordship, the department has a ceiling limit of appointing the work charge employees. Now the ceiling limit with the inclusions of the petitioners in this writ petitions, the WPC 77 of 2024, the ceiling limit has already been reached. And therefore, if these petitioners are included again, your lordship, then it will cross the ceiling limit.
Now, you see, there was a judgment passed by the division bench, by the Supreme Court in this regard of the suitability test early. No. What was the case earlier? Here also the petitioners were in probation.
Yes, your lordship. And the writ petitioners in WPC 77 also were in probation, my lord.
So here the relief which was sought for in the earlier were the termination orders.
Correct.
Now these were the same termination orders which is here also.
Correct.
The same termination.
Same
orders.
termination, yes.
The only thing is there was no interim order passed. That's the only difference.
Yes, your lordship, in the earlier writ petition, the interim was to an extent that the post that was held by the petitioner should not be filled up. And therefore, even if they are filled up after the petition is allowed, the ceiling limit that the government has given to the department to appoint the work charge employees will still be within the ceiling limit.
Then we do one thing, we don't dispose it off. We keep the matter pending.
Lordship.
Allow them to participate in the suitability test.
Lordship.
And after that, whether they fail, matter is over.
Lordship.
If they pass, then we'll consider what is the next thing to be done.
Lordship. Fair enough, my lord.
Because in my opinion, on the ground that you can't say them to be fence sitters.
Correct.
Fence sitters normally, because otherwise here also and there also, because of an order passed by the court, and there was no post kept vacant out there, and did you fill up the post or not? This is a question which has to be brought on by way of an affidavit.
Lordship.
So therefore, we issue a notice and allow them to participate. And their participation out there shall be subject to the final outcome of the petition.
Lordship. Fair enough.
Because here also, in the earlier writ petition also, they have been only permitted to participate in a suitability test.
Correct, my lord.
There's nothing that they should be given the appointment.
Yes, my lord.
So here we allow them to participate. And the question as to whether on account of not applying before this court earlier, shall be looked into as to whether there are actually posts there or not.
Correct.
Chalo? Issue notice making it returnable on June 23rd, 2026. Mr. N. Angami accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the writ petition be served upon him during the course of the day. The petitioners herein were terminated the petitioners herein who were appointed initially by the orders dated 12 September 2023. The petitioner number 1 and 2, who were initially appointed by office orders dated 12th of September 2023 and 27th of September 2023, as operation and maintenance staff. Respectively, by separate office orders, both dated 23/2/2024 enclosed as Annexure 3 and 4 to the writ petition. Were terminated on the ground of keeping the ONM staff within the ceiling limit fixed by the government. It may not be out of place to mention that similar to the petitioners, "72 other persons were also appointed initially and terminated by various office orders dated 23/2/2024 and 24/2024. These 76 writ petitioners, 72 writ persons, being aggrieved with the termination, approached this court by filing a writ petition being WPC number 77/2024, whereby they sought for the following reliefs. Hey, relief kita kot pabo jana, page 44 to 1, 2, and 3. During the course of the hearing, Mr. N. Angami, appearing on behalf of the petitioner, respondent, submitted that when the writ petition being WPC number 77/2024 was filed, the learned coordinate bench of this court had, while issuing notice, have directed that these 72 posts should not be filled up.
Correct.
And accordingly, the 72 posts in respect to the writ petitioners in WPC number 77/2024 were not filled up. The records further revealed that by the judgment and order dated 23/10/2025, the learned coordinate bench of this court did not interfere with the termination order. Be that as it may, it was noted at paragraph number 39 of the said judgment dated so and so. That the ceiling limit was 2,000 and the existing staff were 1916, thereby denoting 84 vacancies, which arose after the termination of the petitioners therein in the said writ petition. The learned coordinate bench disposed of the said writ petition, thereby observing that the equity would prevail if the petitioners in the said writ petition are allowed to take part in the suitability test as per the condition in the appointment order. And the respondents were directed to consider the prayer of the petitioners to participate in the suitability test against the vacant post as reflected in the RTI reply, or in the event of any vacancies in the future as per the existing norms and rules. It was further observed by the learned coordinate bench that the respondents it was further observed and directed by the learned coordinate bench that the respondents should consider the age relaxation of some of the petitioners who have crossed the age limit by considering the age according to the appointment order. And the process be completed as expeditiously as possible from the date of the said judgment and as per the norms as well as the prevailing office memorandums. The record reveals that the respondents have duly had accepted the said judgment and did not file an appeal thereagainst. This aspect of the matter is further apparent from the decision, from the communication issued by the Chief Engineer PWD, PHED, Nagaland, dated 24/2026, whereby the Executive Engineer PHED, Kifri, PHED of various divisions were directed to issue immediate calling letters for conduct of suitability test. The case of the present petitioners herein is that the petitioners herein were not parties to the said writ petition. And as such, no calling letters have been issued to the petitioners. It is the specific case of the petitioners that the petitioners herein are similarly situated to that of the writ petitioners in WPC number 77/2024. Therefore, the petitioners herein are entitled to a similar treatment merely because of the fact that the petitioners have not filed their writ petition. The petitioners should not be denied a chance to participate in the suitability test. Mr. Angami, I've seen the directions passed. There's nothing. There have been only again, because as of now you have 84 tests.
Yes.
Then vacancies are already there. As per the judgment,
Yes.
it is clear that 84 is there.
No, Your Lordship, yes, while passing this, disposing,
84
yes,
is there.
84 was there.
So thereupon there is the direction. This judgment was passed only when?
Your Lordship,
On the 23/10/2025.
correct, my Lord.
So thereupon, there was a direction.
Yes.
So that as on that date, it was 84 posts were there. This is the finding.
Lordship, yes, this is the
So
finding.
therefore, the question is, they want to participate only. There's nothing else, because I would have understood. I was thinking on a different level, because what has happened, if you remember, there must have been here also some cases I heard it. In fact, last line when I was taking up that matter was going on, whereby the question was, what has happened? Those persons, some teachers were not having a particular suitability.
Lordship.
There was no suitability of a particular persons, those teachers. Therefore, there were various judgments passed by the Supreme Court. Supreme Court says that, okay, within this period, they may appear and give their exams. There were many litigations on that. I was thinking on that. Here, there was nothing. So says that is there vacancy, kindly allow them to do it, and if there is an age relaxation required, give it. That's all.
Yes, your Lordship.
So therefore, the question doesn't arise. There is nothing out there that to select or consider. Even nothing to that effect also.
Yes.
Now here the petitioners, here the age would be,
Petitioner 1 is 28, 2 is 31.
so age relaxation is also not there.
No.
So therefore, so if these persons, 28 and 31, they come say similarly to this. It's an absolute similarity. Only that they want to participate in that. They are also similarly situated. On the same ground, it has been terminated.
Yes. Your Lordship, as far as similar situation is concerned, correct.
So there is no point in keeping the matter pending after these directions.
The
Makes
only
no sense.
Your Lordship, the only thing is whether these there are still vacancies left or not. That's the only thing.
Whether there is vacancy there or not, I'm not. The court also never said.
Correct.
Court also never said that.
Yes.
You see the last line of that order,
Yes.
which makes everything different. You see, this process to be completed and expedited from the date of this order and as per the norms as well as the prevailing office memoranda and orders.
Correct.
So this will be dependent upon, this order will be dependent on vacancies. 72 where there was a stay was granted.
Yes.
But as on that date on which the order, it is the court categorically mentions that there is 84. So there is 2 more.
Your Lordship, this 84 posts, if I may be allowed to explain. Your Lordship, these 84 posts, these are also a post which are, if it is a regular post, these are to be filled up through the work charge employees who are on the work charge category.
You fill up whatever may be. I make it very clear. If there is no post available, that's a different thing. They will participate. You see, the suitability, I don't understand what is this suitability test. There's no suitability test business. It is the test by which they should, there was most probably, there were no, what you call, selection most probably.
Yes, there was no selection, madam.
So therefore, these persons have been given appointment. In fact, the learned coordinate bit with due respect should have cut short at that point of time itself.
Correct.
When there was no officeman, nothing out there, where is the question? But by this judgment out here, the learned coordinate bench says that, okay, consider their suitability. What is this suitability business? But the fact that they have asked to let him also be there in a part of that illegal process makes no sense coming out here. After you should not have accepted this. You see the police case. I've terminated everybody.
Yes.
It's a different thing. You go ahead, whatever may be. You can't have a separate exam for them because this will be in violation of Article 14 and 16.
Correct. Without having any examinations being conducted.
It cannot be only limited to these people.
Yes, correct.
It has to be for everybody.
Correct.
Now, if you are only having them only, out of only 84 posts or 76 posts, you are going to give them and giving. So what is that exercise? It is a mere formality.
Yes.
Isn't this order a mere formality now? And therefore, you are saying that there's no post.
Lordship.
It appears to be so.
Yes.
Now have the exam only on this suitability. What to do? Anyways. Kiri. This court I have duly taken note of that what has been directed by the learned coordinate bench of this court in the judgment and order dated 23/10/2025 is for granting and giving a chance to the petitioners in the said writ petition, being 77 of a year, to participate in a test for evaluating as to whether they are suitable or not to the posts. First of all, there is no direction passed by the learned coordinate bench that those petitioners who participate in the suitability test have to be granted the appointment. The same, it is also very pertinent to observe that the learned coordinate bench has categorically mentioned that the conducting of the suitability test shall be made in terms with the prevailing office memorandum as well as orders, which in the opinion of this court also would include the requirement of following the mandate of Article 14 and 16 of the Constitution. First, in that circumstances, it is therefore the opinion of this court that merely because of the fact that the petitioners herein did not participate in the earlier round of litigation, the petitioner cannot be barred from not participating, not being permitted to participate in the suitability tests so proposed to be conducted. If that is so done, it will not only violate the mandate of Article 14 of the Constitution, Article 14 and 16 of the Constitution, qua the petitioner, but against all persons who are entitled to be appointed to those posts. Considering the above, it is therefore the opinion of this court that the petitioners herein ought to be granted an opportunity to participate in the said process for evaluating the suitability, taking into account that the petitioners are similarly situated to that of the writ petitioners in WPC number 77 of so-and-so. Accordingly, the writ petition stands disposed of with the following observations and directions. First, this court observes and directs that the directions so passed by the learned coordinate bench in the judgment and order dated so-and-so, passed in WPC number so-and-so, cannot be limited to only those petitioners who had approached this court in WPC number so-and-so, and the benefit has to be also granted to all other persons, including the present petitioners. Else, it would be in violation to Article 14 and 16 of the Constitution. Number 2. This court further directs the respondent numbers 1, 2, and 3 to provide the benefits to permit the petitioners as well as those who were similarly situated to the petitioners in WPC number so-and-so to participate in the tests so conducted to evaluate the suitability. First. Number 3, this court further observes and directs that the learned coordinate bench of this court in the judgment and order dated so and so did not only directed evaluation of the suitability to the post of O&M staff and did not direct the appointment of the petitioners therein. It shall purely lie within the domain of the respondent authorities to evaluate as to who would be entitled to be promoted, to be appointed to the said post based on the suitability.
Lord.
With above the instant petitions is disposed.
Deeply obliged, my lord.
So on top, I'll remove that issue notice.
Lordship.
Because it makes no sense.
Yes, my lord. Yes, my lord.
So therefore, Article 14 and 16, you have to follow Article 14 and 16.
Wonderful order. Your
And
Lordship.
then
Wonderful
you
order.
may very well consider
Yes.
giving opportunity. You may only give them age relaxation.
Yes. In fact, Your Lordship, this particular judgment and order was actually a little confusing to the department also. Now it has been made clear, Your Lordship. I'm deeply obliged for that.
So
my lord.
therefore, you, in respect to this 84 post or whatever may be post, you have a suitability test. Allow them to participate along with others.
Yes.
In
yes.
fact, in essence, if you get the judgment, the court did not interfere with the termination.
Correct.
What they
correct.
say, you hold another examination.
Yes.
The courts only meant did not point one single thing out there that it should everybody will have a right to participate.
Yes.
In
yes.
fact, you have to, otherwise it will be in violation of Article 14 and 16.
Correct. Correct, my lord.
Only given them that they will give age relaxation.
Yes.
And in fact, his age relaxation is not there. But then also, he had to come because you are only concentrating on 76. That is what you also, your submission also says so. You are only thinking, meaning thereby they will come and you will give them the job.
Your Lordship, I cannot interpret the court order in my version, Your Lordship. Now that it's very clear. I'm deeply obliged for that, my lord. Deeply obliged. my lord.
For hearing, item number 19.
What is this matter?
Someone whose service has been categorized as excess, though appointed on a regular basis. That is my case.
Promotion.
No consideration for promotion since the date of entry into service. All those appointed after the petitioner, all promoted.
All?
All promoted.
You have not been
I have
considered.
not been considered at all on the ground that the tag excess is appended to my service.
Huh?
The tag of excess
Excess.
is appended to my service.
Where?
Page 40. No, this one. Page 45 of the senior. Page 45, my seniority list. And your Lordship will see my name is at serial number 11. At the remark column, on the last column, excess.
What is excess? Yes, Mr. Mohan. What is this excess?
Lordship will find in page 2, para 4 of the state content. Page 4 and 5.
Was appointed without a sanction and also without the approval of the government in the interest of seniority. As of now the question is without an sanction post he was appointed.
There was no pause, actually. There was no pause, but during 2009, there was no sanction post, I mean. So, however, he was been appointed. The petitioner was been appointed and he is serving till today. There is no dispute about that.
To the government for necessary examination. However, the authority of the act will not proceed the fact but what is required concurrent due to the fact that was appointed without granting power. So here, in view of this, Mr. Counsel, the problem is that you have to ask for either regularization or by creation of a supernumerary post.
No, my lord, if your lordship will kindly see paragraph 3 of my petition. Paragraph 3.
Yes.
The
On
appointment
the
petition about the
is
appointment
currently
basis
serving
in
a year.
fact,
So,
1/5.
so therefore, from 2009,
Yes, ma'am.
if that be so, if this, no, my question is, Mr. The problem is that if this is so,
Ma'am.
you have, let's see your appointment. So and so
Page
is
15.
appointed as sub-inspector of supplies under so and so plus other allowances as per admissible under rules.
Yes, ma'am.
Now, this is in 2009
Yes, ma'am.
and forwarding of the tentative list. Now, my question is thereafter,
Ma'am.
you have been getting your salary,
Full benefits of service.
full salary you are
Yes,
getting. You are also getting various, what you call, ACP?
Yes, ma'am.
ACP you have
Yes,
got.
ma'am. Yes,
Now, ACP is given to the regular employees. So, have you filed your reply?
yes, my lord.
What do you say?
Your lordship at paragraph 5. Paragraph 5. And at page 5. Page 5.
How were you appointed? Pursuant to an advertisement?
No, ma'am. No, there was no selection process.
Then?
I was appointed. And my lord, your lordship will see in paragraph 8,
Understood, but Mr. Jimumi, how were you appointed in 2009 without an
without any
advertisement?
selection process.
Then?
Ma'am. And so too were all the persons who have been mentioned in paragraph 8. All appointed after me,
Without advertisement?
without advertisement. Same manner.
Where have you mentioned?
Paragraph 8
Of?
of my writ petition. At page 5. Paragraph 7, paragraph 8, ma'am.
Now, this person at Annexure 3 of your writ petition is senior to you?
Petition 3, please, no. No, my lord, this is someone who was appointed in year 2011.
Understood. Is he senior to
No,
you?
ma'am. After me.
No, understood. So you are saying that you have never been considered for promotion.
Yes, ma'am.
Has he been considered
Yes,
for
my lord.
promotion?
In fact, your lordship will see in paragraph 7, I have mentioned. Paragraph 7, paragraph 8.
No, it's okay. My question is, I'm not on that excess here. My question is whether these persons have been promoted.
Yes, my lord.
I'm concerned about
Yes, sir.
the person in Annexure 3. What is his name? Ninu Jumu. Ninu Jumu. Where is his name?
Your lordship, I haven't enclosed the promotion order.
No, it's okay, no problem. But in the list it will be there, na?
In fact, I have mentioned it in the paragraphs 11 and 12, my lord, but I have not
No,
mentioned
no,
the
no, no.
specifics.
Seniority list of inspector. Ah, yeah. This person, number 9, page 47.
Yes.
What is SIS?
Sub-inspector of supply.
Here is an inspector, this fellow, see. Ninu Jumu. He's a promotee.
Yes, ma'am.
So he has been promoted.
Yes, ma'am.
Now, a person who has been appointed on contractual basis, you have regularized him. My question is this for this.
Lordship, regularization order is not there in my documents.
So therefore,
If,
wouldn't that be a violation taking into account that the petitioner herein was appointed in the year 2009? Kindly see Annexure 1.
Page 27 is a regularization order. Page 27 is a regularization of this group.
So he was brought later on.
Yes,
You have regularized somebody, but not the petitioner. So, Mr. Zimmerman, the order which I have to pass in these type of cases would be that your seniority has to be taken from then 2009
Right.
and given the whatever benefits you are entitled to. Now, you see, the question is, in view of their affidavit,
Right.
where they say that you have been appointed against a non-sanctioned post, what is your stand?
Your Lordship, it is a contradictory statement. It is a self-contradictory statement. Because in the very same affidavit, Your Lordship, in paragraph 3, in the very same affidavit of the government, the paragraph 3.
Paragraph 3.
This is a very short paragraph. But what this paragraph says is.
But it is the most important.
Yes, ma'am.
Yes.
That with regard to the statements made in paragraphs 1, 2, 3, 4, 5, 5.1, 5.2, 6, 7,
None
9,
of
10,
any
13, 14.
comments.
All admitted. Fully admitted, ma'am.
No, my question is therefore, when you were appointed
Madam.
against a non-sanctioned post, that they are saying,
That they say.
what is your reply?
I'm saying it is an incorrect statement. I'm saying I have replied to that matter in my affidavit. At page 5, Lordships.
So therefore, this court has to come to a finding
Yes, ma'am.
as to whether you were appointed against a sanctioned post or not.
My lord.
It is they who are saying so.
My lord.
If they are saying so,
My lord.
it is their burden to show it.
Yes, ma'am.
And apart from that, a person who has been appointed on a contract basis in 2011,
My lord.
he has been then promoted, regularized in 2013. But a person, that means there is a post.
Yes. There was actually a post.
Now they are very silent on the aspect pertaining to how these persons were brought in the fold of the state. You are very silent. You don't want to show what you have done.
No, the petitioner is working.
But
But,
the problem is that the moment I'm taking up all this thing, these people are also not parties.
They're not parties.
Now tomorrow, if I allow your petition
My lord.
by removing their excess,
My lord.
their excess, they say that they have been brought as excess because you were posted against a non-sanctioned post. I have to come to a finding to that effect that it is not so.
Well,
Because they have not produced anything to that effect, just making it. Then you will be entitled for consideration
well,
for promotion.
well.
Now, if you are entitled for consideration for promotion, it will date back, your seniority has to date back from 2009. Now, 2009, if it dates back, can I pass a consequential order that you should be granted with notional benefit? Because if you give way, then those persons who are above you, they will be affected.
Yes, ma'am.
How do you take care of it with only making 1 and 2 a party?
Well, that aspect of the matter was also there, madam. And if I may,
Please.
the petitioner was only considered about making her service a regular service post.
And keeping him for last so many years on a non-sanctioned post for last how many years? You find
17 years.
2009, madam.
25. 2025, from 2009 onwards, for the last 16 years, paying him the regular salary. How are you paying the regular salary if it is a non-sanctioned post? Where do you get the money from?
Money is from the state.
The state cannot pay. You see, posts are what? There are planned posts, non-planned posts, or the state planned posts. Planned posts are funded by the planning commissions, or it is being funded as certain by the government against that post. These are for a particular period. Just for example, you have those various schemes, works where you are having, these are planned posts. Non-planned posts, you have to charge it under 204, Article 204 against that. That this is the amount which is payable for this.
Correct.
Now, if there is no post,
I think that your lordship is quite correct. Now, you see, let us go back to 2009. A certain man retired, maybe, that is 70 years back. So certain men might have retired or died. There was a vacancy. So ultimately, the petitioner was appointed. Now,
it's a vacant post.
that is why I'm saying. That is my presumption only, because up to that extent of the instruction, I haven't got. But that I'm presuming that now, once a person has to be appointed, the director concerned should have to forward it to the government for approval. And then once the approval is accorded, then he become a full-fledged employee.
Then are you giving him?
Now, what happened in the case of the petitioner is that he was appointed and from the directorate itself. Now, our department wants to help her, but we have a department, lordship is well aware, the Department of Personnel and Administrative Reforms. So when the matter of the petitioner was examined, didn't find any merit. So ultimately it was rejected. It was in the year 2001. Your lordship, may kindly see the last page of my counter. Annexure 1, page 6. This is what we have written to the government, and so the appointing authority of the petitioner was the director during 2009. So because of the representation being submitted by the petitioner, we have forwarded it to the government. The appointing authority, the person who has appointed the petitioner. But it was not considered.
Mr. Zimomi, you need to amend your petition. Kindly see your representation.
My lord. My representation,
You say
my lord,
that you have not regularized me
my lord,
with others
Right.
who have been later appointed.
my lord.
So if that be so,
Right.
if you have not regularized me, shouldn't you therefore have the prayer?
My lord, the representation is wrongly worded. If you may.
No, this is your main crux.
Yes, my lord.
This is what you have, you see, what you are asking for a mandamus.
My lord.
So you have demanded justice and the justice has been denied, therefore you are before us.
Yes, ma'am.
What?
Yes, ma'am.
So what is the demand?
My lord.
You are not you kindly see paragraph 3. In the circumstances, I submit this representation and pray that the government may kindly consider passing appropriate in relation to my service.
Yes, my lord.
There can be no justifiable reason for those appointed in similar manner as me
Yes,
to
my lord.
have the benefit of regular service
My lord.
and to deny me those same benefits.
Yes, my lord.
So therefore, you therefore have to ask that in
Yes.
your prayer.
No, that is what I am asking for, my lord.
No, see
what-
your relief.
My lord.
Your
Yes.
relief is kindly remove the excess from me
Yes, my lord.
and promote me.
Yes, my lord. So they're using the word excess to deny me the benefits of regular
This is not
service.
how you do it. You have to categorically mention that, look here, this is a discriminatory treatment which you are giving me. What are the other persons who are there?
My lord.
One.
My lord.
Secondly, who has not done it?
My lord.
Food and Civil Supplies have also given it.
My lord.
Who has not done it is the Department of Personnel.
My lord.
Department of Personnel is not a party.
I can do that, my lord. I can amend the petition. Yes. I can do that.
Not only that, you have to change the entire basis. You have to ask that, you see, this is the treatment which has been given.
My lord.
I am similarly situated with those persons.
My lord.
They have been appointed subsequently. They have come up with an affidavit out here to say that my post have not been regularized or I was appointed against, whereas after me contractual appointments were there, these people have been regularized, whereas my post remains. All this while I have been being paid the entire amount. After being paid the entire amount, therefore, without a post, how can they make the payment?
My lord.
So
I have said that in my reply, my lord.
So therefore,
My lord.
without this, it cannot. So therefore, you have to be considered to be either given that benefit of appointment on 2009 itself.
My lord.
It has to be merely stating out there that there was no post. They have not indicated which post was not there, how you were appointed. You see, the government cannot get an extra penny.
My lord.
For contractual appointment, it's a different thing. There's no problem with that getting it, because they put it as a, when you submit your budget, they put it as an extra demand
My lord.
for a particular reason. But for the purpose of a payment of a regular scale on a regular pay,
My lord.
it has to be against the post.
My lord.
So these things you need to do it. I think you need to withdraw with the liberty to file. Otherwise, you'll have a problem with this. Your entire basis is changed. Take into account that affidavit, and now you have to improve it. You have to make the personnel department is the main purpose. So what do you have to do? You have to amend your petition. Once you amend it, you file an application. The application, after you file, this court will pass an order, then it will amend. So better withdraw and file a fresh one. Take the cause of action on the basis of the affidavit and then come up that this is not a stand. This is how you have to do it. Then look into that judgment of recently. There's a division bench judgment. I passed a single judgment. That judgment has been set aside by the division bench, partly. That judgment is very interesting. What has happened? These people were appointed pursuant to some form of advertisement, no advertisement as such. But the fact remained that they have been, how these appointments were made in Gauhati were these. They were appointed initially as grade 4 staff. After being appointed temporarily, they were transferred from one district to the other. Now, against the transfer, it is against the vacant post. When you transfer it, it's against the vacant post. So once they get into the vacant post, they are getting the salary. Once that salary was given, so this is how it came up before me. I said nothing doing. This is in violation of Article 14 and 16. I said as. But the division bench went out and said that no, you have been continuing this for all these years by making payment against that. Without doing anything, you cannot now say that they are not entitled to. And therefore directed them to do it. I'll give you that. To improve your case in that manner,
I can do that.
I'll give it to you, that judgment. Huh? Right. Recent judgment of a division. Huh? I'll give it to him. You
Very well.
collect. So you have to improve your case on that.
We'll do that.
The post in which. So that is one. And then your basic idea is, you see, apart from that, this is a secondary argument. The first and foremost that you have been regularly appointed.
Yes, ma'am.
They are to therefore say that they are not regularly.
Right.
But your affidavit out here is you have to say that this representation has been done under compulsion because you are not being done. This is how it has. Unless you don't explain this. And therefore, your seniority has to be counted from them and mark those persons who have been promoted. And you have to make them a partner. Because then only you can go it. Or are you just saying that you are want to be promoted today?
That was the idea, my lord.
Now,
As
if
far
you
as
ask me that, then you will be much junior to those persons
Of
who
course.
have been appointed senior. Therefore, I say the inspector. All these inspectors, the person has now been appointed as inspector in 2024. The person who was initially appointed in 2011, you were appointed in
Yes.
2000. This person was regularized in 2013.
Right.
So therefore, your seniority has to be taken from there.
My lord.
And you have been all along, you were never informed you have a service book.
Yes, ma'am.
You have a service book. A service book cannot be created of a person without if he is not a regular
Yes,
employee. Well, use those.
I have mentioned all that actually in the petition.
Understood, but not in this.
No, your lordship.
You want to do it, I can go ahead with this. But you, at the end of the day, this court cannot enter into that point.
Hello.
That is the problem. If I can enter into that point, it's a different thing. But the problem is you have to bring those aspects.
In fact, my lord,
You therefore say that there can be no justifiable reason for those appointed in similar manner as me to have the benefit of regular service and then to deny the same.
my lord.
Means, are you not admitting by yourself that you are not in regular service?
On the flip side, my lord, I am saying that I am in regular service, but the regular benefits are not being given to me because of retired excess. Just purely because of retired excess. And in fact, your lordship, on the last occasion when the matter was heard last week, the government advocate was, for another friend, was related to place before this honorable court as to the number of sanction posts at a time when I was appointed and the current number of sanction posts in the rank of SIS.
The rank of?
SIS, the entry point.
What is the sanction post?
I got it there.
Was there any post sanction?
There were 28 posts at that, it seems.
Lordship, page 2, page, I've written in green paper. Green ink. Page. Lordship, page 4 is the first appointment order. Page 5 will not be relevant because it is seniority as on 31/3/2008. That is before the appointment of the petitioner. Page 6, Lordship, you will find it is as on 23/3/2010. The last one, it should be 25.
Where, please?
Page 6.
Page 6. Petitioner was appointed in 2009 and this seniority is given on 2010, 23/3/2010.
Then of SIS, Directorate is 6 and establishment is 20. So this way.
Page 6.
Total 28. So there is no plan post. All are non-plan, isn't it? It's under non-plan.
Yes, sir.
So these are 28 posts. Then Accountant General, so Inspector SI 29. Then minimum position in so and so excess. But Mr. Jimomi, you have been appointed as a temporary. It's there in the 2009 document.
Same as all the other orders.
Understood. So therefore, you have to be brought in within the service and regularized.
But your
And
lordship,
that is not your prayer.
no, your lordship, the point is this. In respect of the others, only the person whose name I showed your lordship, who was regularized in service. The others, the first initial appointment order, that is the regularization order. It's the same.
Understood. So therefore, you should be regularized.
No,
Yes, by giving you retrospective effect from the date, the person who were junior to you have been regularized.
your lordship, the initial appointment order, in the case of others, has been taken to be the regularization order.
I'm understood that, but where is the others? Let us see.
Page 29, my lord. Page 29.
Yes. Then
Page 29, then page 31, page 32, page 33.
now understood. Let us assume that this is taken to be the final.
Yes, ma'am.
This is them and liable to termination. So in 2000, now these people have been considered for promotion.
Yes, ma'am. They have.
You have been left out.
Yes, ma'am.
So therefore, you have to ask that prayer that you have to be regularized prior to these people. Have these people been regularized? Most probably.
By these very orders.
How do you say there must be, this is the administrative approval of the government?
Yes, ma'am.
So this is for temporary appointment.
This order has been taken to be the regular appointment.
How?
That is precisely the point, my lord. These orders are the orders of regular appointment.
Against an existing vacancy caused on demise of so and so. The appointment is purely temporary and liable for termination after giving 1 month's notice. The other conditions which are not considered shall be governed by the rules.
The only difference, my lord, the only difference in my order is the last sentence. This has administrative approval of government.
No, it's okay. I'm not on that
Yes.
approval. But you have to be brought within the ambit. Where are those people?
The same orders, my lord. No difference. All the others who have been promoted ahead of me and who have been taken to be regular, the same orders. This is the order of regularization. This is the regular appointment order, rather.
Here, she has become promoted, here, date of entry into service 12, promotion is 17/8/2023. Entry is 16/3. Okay, let us see at 2 o'clock. I have doubts.
The state admits by law that these are the orders by which the others were also appointed on regular basis.
So as on the date of your retirement, as on the date on which you were appointed in 2009,
No, no.
they were all filled up. You do one thing, you make this calculation out here and find out as to whether as on this date, whether there were any promotion, any retirement or not. Just find out from there. If we can think of something.
Very well. page 3, the number of sanctioned posts as of 1/2/2002, 28. At page 3. Now, the Lordship will turn to the incumbency list, which is at page 5. Page 5. So this is as on 21/3/2008. The Lordship will see at the top of the page, and all 28 posts are filled up. All 28 posts are occupied as on 31/3/2008. The next incumbency list, which is as on 23/3/2010. On the top corner, have the Lordship seen that? As on 23/3/2010. And here, my name is the last number, serial number 25. So as on 23/3/2010, I was occupying a sanctioned post. In addition to the post I was occupying, there were 3 more vacant posts.
So there is you are the 25th.
Chairman, 25th. So the affidavit which has been filed by the state is not a correct affidavit. So I was appointed on regular basis against the sanctioned post.
You are not appointed. You are appointed against the sanctioned post, but not on regular basis.
I am saying, my lord, it was
You
on-
cannot say also, because your appointment has not been regularized.
No, my lord. That is the whole issue. So the appointment order which was issued to me is the same appointment order in respect of all others.
But they had the administrative approval of the government.
That is what they say, man.
It
That
is
is what
there,
they say.
written out there in the orders.
Yes, my lord, that is what they say. And not only that, they say they were appointed against vacancies, and the vacancies are named. So they were a specific purpose, and that is to deny me my claim. that I was appointed.
All said and done, you were appointed against the vacant post.
Yes, sir.
There's no quarrel with that proposition. But without the administrative approval of the government,
That's what I say.
how do you take care of that?
My lord, it is too late in the day. If I may say so, my lord. It is too late in the day for them to say that I was appointed without minister. Without administrative approval, my lord, without administrative approval, I could not have been given the benefits of regular service. The full benefits of regular service.
So as on date, there are vacancies.
7 vacancies.
And not only vacancies here. Now, Mr. Inchin, tell me, why is it required for the administrative approval of the government? There must be a notification.
This. The notes of the beginning will be. What on the room? You may tell this. Last bit.
Eleven and 12. 11 and 12. You are referring to which one?
That I have marked. And the subsequent page, you'll find disposal of government buildings. Forget the page, or should, you'll find it as subsequent page.
But you cannot get any seniority over these people. Because they are not parties. We can only give a declaration to the effect that there will be a deemed administrative approval in view of the conduct of the state. Now, the personnel department has not done it. No? Your problem is because of the personal.
For legislative approval, it has to put it there, which is the approval department. It has to put it there.
Meaning,
That is my question. From the department, that we put it there. And then, like that.
Your Lordship will see in the government section.
we do one thing. We make the personnel department the party to the process. Take their stand also. We make it them and let us take their stand. Without them, it will be because you are in favor of him. Not you, not Mr. Mohan. The food and civil supplies department is in favor because you are also asking that he should be regularized. If you see your affidavit, kindly see this particular document. See the document at page 6.
Yes, okay.
So you are supporting his case.
Yes, yes.
Who is against that is the government, more particularly the personnel department, the ministry, the Department of Personnel Affairs.
No. If the repair.
Yeah, the Department of Personnel and Administrative Reforms.
The director should write to the secretary concerned of the department. And then secretary will forward it to the BLA. And then once the concurrence is given by the BLA, then the restart.
But you have moved it. Food and Civil Supplies Department have moved it.
No, they have not moved, Madam. That is the point. Your Lordship will see at page 3. of the government section. Page 3, government section towards the middle after excess. It is also stated that the Office of the Council and Respondent has forwarded the explicitly self-explanatory application for regularization of the patient with the necessary examination and consideration thereof. However, the authority of the government would not proceed to file the Department of PNL by forwarding required concurrent due to the fact that the petition was appointed without any second.
So this is an affidavit filed by respondent number 2. Not by respondent number 1.
1 and 2, madam. By 1 and 2.
How can 1 and 2 file it? The deponent has forwarded it.
Correct. Respondent number 1, number 2 has filed there.
This is an affidavit by respondent number 2.
Yes.
The inaction on the part of the respondent number 1.
No, not this, they have a communication. What we do.
Understood, but you,
What we do
but
here-
the respondent number 1 has not forwarded to the PNR department.
This is in 2022. Because he might have forwarded, respondent number 1 might have forwarded to the BNR department, but it might have been rejected.
That's not the matter.
That is the assumption. And BNR department is not in that, elected as a party company.
PNR.
It's not elected as a party company.
Without the PNR's concurrence cannot happen.
No,
Now, who gives the administrative approval of the government?
that's be given by the BNR.
PNR. And he is not a party.
Not a part.
How can I deem an administrative approval without the PNR as a party?
No, BNR will give you single.
Understood.
Once they said, okay, may, look at that.
Now, if I pass an order to be a deemed approval,
Yes.
administrative approval is there. Can I do so without the PNR as a party? without the PNR being a party, can I do so?
My instruction is up to that extent only, that they have said to the government, and then
And thereafter, there is no mention whether the government has sent it or not, because here it says, kindly see, you see, it is also stated that the office of the answering deponent has forwarded the explicitly self-explanatory application to the regularization of the petitioner to the government for
Correct.
necessary examination and consideration thereto. However, the authority of the government could not proceed the file to the PNR.
yeah,
So therefore, this respondent number 1 has not proceeded with to the PNR for affording required concurrence due to the fact that the petitioner was appointed without any sanction post and without affording the approval of the government.
that is why respondent number one, the office of the respondent number one might have presumed that, well, they have so many.
No, understood. No, Mr. Imchal, I understand. The respondent number 1 is the government.
Correct.
Respondent number 2 is the directorate.
Correct.
The directorate has forwarded it to the respondent number 1, the government.
Correct.
The government is the administrative department.
Correct.
This will forward it to the PNR. There are two nodal other departments are the PNR as well as the finance. These are two other departments which
Correct.
have to be, concurrence has to be made.
Now, what I'm going to see, your lordship, is that the government, in its own application of mine, might have come to the conclusion that no, this is like this, the situation is like this,
So we can't send it.
so it might have all been like that, because the government has the authority, secretary has the authority to examine and let you know, this cannot be protected.
So
You
therefore,
might have,
so
you might have drawn that conclusion.
therefore the decision, the affidavit which have been filed only says that the directorate have sent it.
Correct. Also,
The directorate is in favor of the petitioner to be regularized. Whereas the respondent number 1, that's the secretary of the administrative department, they are not in favor. And therefore they have not proceeded to the PNR.
because, as I said, you might have, the administrative department might have come to a conclusion that, no, it is not possible.
But it appears from the materials which have been produced today, there was a sanction post.
Sanction post is the, oh,
No, because there were 28 sanction posts. It is from your instructions.
right,
There were 28 sanction posts. Of these 28 sanction posts, as on 31/3/2008, all the sanction posts were filled up. As on 31/3/2010, the petitioner has been put at serial number 24, 25, meaning thereby the petitioner's appointment was against the sanctioned vacant post. There's no quarrel with that. Only hitch is there was no administrative approval taken.
right.
For a temporary post, there is no requirement of an administrative approval. Just because he has been appointed just temporarily. But the moment it is brought within the services of the state, then you need the administrative approval. Now the petitioner case is, in pursuance thereto, you have appointed many people as contractual as well as temporary, but these people have now been brought within the services, have been promoted and everything has been given. The only difference between the petitioner's case as well as the other persons is the last line which have been mentioned, that it has been appointed against with the administrative approval. But these appointments of those persons, one person is okay, who have been regularized in 2012. That Mr. Juma, that is okay. But rest of the people, they still continue to be as a temporary unless they have been brought in by doing the needful, some additional orders. Now the petitioner says that I also stand in the same footing of that of the others, except the fact that there is this aspect is not being mentioned of administrative approval. But the fact remains that the last 16 years, you have continued my service on the scale of pay, giving me as MSCPC. You have given me that also. There's a service book being maintained. Everywhere you have also put me as in the seniority list also. But merely on the ground that the administrative approval has not been taken, can you deny me the rights, which otherwise it is a deemed administrative approval? That's the petitioner's case. So therefore, this court has to come to an opinion that there is a deemed administrative approval. Now, can this court do so without the PNR being a party, taking into account that the PNR is the authority who gives the administrative occurrence? My question is that. Mr. Jimami.
I can make it important one.
I think you need to make them a party, yes, and you have to amend your petition by inserting that prayer. That prayer has to be there, that it has to be a deemed.
Well, I can.
That you do it. If you don't do that, the problem lies with at a later stage for this court to pass the order.
Very well.
And you see, the moment I pass that order, the thing will be tomorrow. They may file an appeal. Then look here, he never asked for anything in his prayer. Now you have these documents now.
Yes, sir.
These documents will help you to come up with a categorical finding.
Yes, sir.
That look here, as on there, they cannot say that there was no vacant post. There was a sanctioned vacant post as on the date, and they have put me as 25.
Yes.
After that, these persons have been appointed. So therefore, if these persons have been appointed and they have been regularized,
yes,
you should be also getting the benefit. You may not be entitled for interstate seniority with those persons, taking into account that these have happened for a long time.
Yes.
And you may not get it, but your right to be considered for promotion is an important right, it's a fundamental right. So therefore, you have a case, but this case means in the form in which the petition is there, it's very difficult, Mr. Jimmy. And that's why I'm a very technical person, like those matters.
We can see that. We can see that. We can see that.
No, I have seen it. The reason why I'm doing so is there's a reason why. I've seen it in many cases that appeals are being allowed only on these small aspects. Later on, after getting a judgment from this court also, you may not get the benefit. So, this is the only thing I have. Otherwise, there's no problem with it. You file an amended application.
I am very grateful to my friend for producing all his documents. We didn't have them.
Would it serve your purpose for going for an amended petition?
I would be. Why not, if I may explain? We have an affidavit which is already there on the court, where affidavit filed by the state, which is already there on the court, and certain clear admissions have already been made. I don't want.
No, that affidavit will be a part of your petition.
Yes.
So therefore, with these documents, if you bring in, wouldn't it better to have a consolidated writ petition?
Why not? If I may.
Because what happened is this, I'm telling you, you'll file an amendment. Amendment petition, I will allow it.
Right.
Once I allow it, then what will happen is you have to file again a consolidated petition.
Right.
are you not doing twice the work for instead of filing one application? My question is this.
My lord,
And that too, this court will have to pass the order allowing the amendment, then you file a fresh petition. Because at the end of the day, you have to, again, once you amend it, you have to again file it.
yes, sir.
Once you file it, you have to give the PNR a party.
Yes, sir.
Notice you has to be given for them to file an affidavit. Does it make any sense for you to again amend it by taking 3 dates? This is 3 dates.
I will feel, if I may, I will feel more secure with that step. Because I may not have the benefit of this argument this case with your lordship here.
No, therefore, you file it immediately on the Friday. I'm taking it up. I'll take it up move it on Friday.
So amendment part is all right, or withdrawal with limited filing is fine.
I'm asking you, why don't you go for a new writ petition, bringing these aspects, and ask that prayer? Administrative approval has been deemed. It is a deemed administrative approval to be given effect from the date of your birth, from the date of your service, because they have other person. If you see, just for example, kindly see this person. They have been the person, other persons. Kindly come to page 47 of your writ petition. Kindly come to number 11.
Yes, sir.
Deblu Chanbeni Lotha.
Yes, sir.
She was the date of first entry on her date of appointment is on 15/3/2012.
Yes, sir.
That is only mentioned that she's also temporary, but with the administrative approval. Her date of this is being relegated back. Her seniority is being relegated back to 16/3/2012. Now, as of now, what you are asking here, can you get those benefits? So therefore, why don't you ask this? I'm trying to help you out, but
No, I understand.
my question is, there are 3. What is going to happen? You file an amendment application. Once you file an amendment application, this court will allow your amendment. Let us take it on a very positive note. Then you file a writ petition, the consolidated writ petition. PNR becomes a party.
Yes.
Their stand is known because you are going to enclose that affidavit. That's the reason. PNR has to be brought in.
Yes.
As to whether, as regards the administrative approval part, why it should not be considered to be an administrative approval. Then PNR is brought in. Once PNR is brought in, the effect is they will be entitled to an affidavit.
Yes, sir.
Once they file an affidavit, they may say whatever may be, then the court can decide.
Yes.
This is the state of affairs. Now, this second step of PNR filing an affidavit can always happen once you file a new writ petition also.
Right.
Isn't it the same thing you are going to do it? But you enclose these documents.
Right.
Now you have got this.
Yes.
In view of these documents, don't you think that it is now a good case for coming up? Because you need to bring these on record.
I need to be.
This will clearly show that there are 2 deficiencies. One is you were appointed against us, not a sanction and an vacant post. It is not correct
Right.
because you are at serial number 25 against 28 post 1. Only question is the deem approval. It will be a case of deem approval. And they cannot now say that there is no deem approval.
I'll do that, my lord. I think, yes. I will bow down to your lordships.
Hmm?
I will bow down to your lordships. I'm grateful. I'll withdraw the.
You do one thing. I'll have it tomorrow. Think about it overnight. Whether you can proceed with this, taking into these documents. Tomorrow you can withdraw and move it on Friday. I'm here.
I'd rather do it with your lordship's leave.
No, I can.
And I can get it.
Hmm?
Especially as the lordship said, in the case of these documents.
Because otherwise, You are filing there are three proceedings which will happen. One, filing an amendment. Secondly, making another party. So you need two applications. One is amendment, one is an interlocutory application of the PNR. Secondly, you have to, those two applications has to be allowed.
Yes.
Pursuant to those allowing, you file again the writ petition.
Yes.
So it is one and same. Heard Mr. A. Jimomi, the learned counsel, appearing on behalf of the petitioner, and Mr. Mua Imchen, the learned government advocate, appearing on behalf, senior government advocate, appearing on behalf of the respondent number 1 and 2. The learned counsel, appearing on behalf of the petitioner, submits. No, the materials and reports show that the petitioner herein was appointed temporarily by an order dated 30/4/2009 on a scale of pay with effect from 1/5/2009. Annexures 3 to 11 are various appointment orders of persons appointed pursuant to the petitioner, whereby a perusal of these annexures would show that except Srimati Ninu Jumu, who was appointed on a contract basis and subsequently regularized by an order dated 13th of June 2012, all other persons were also appointed in a similar manner in which the petitioner was appointed. There is, however, an apparent distinction between the appointment order of the petitioner and those persons appointed from annexure 5, annexure 5 to 12, 5 to 11, is that there is a mention of an administrative approval of the government. The records further reveal that those persons who have been appointed from annexure 3 to annexure 11, they have been considered for promotion and promoted, whereas the petitioner still continues as in the post of sub-inspector of supply. It is under such grievance. In addition to that, in the seniority list, the petitioner's name has been mentioned against, a remark has been put against the petitioner's name, showing as excess. It is under such circumstances the petitioner approached this court by filing the present writ petition. for deletion of the remark access against the petitioner's name in the seniority list, and further, that the petitioner should be considered for promotion as it is a fundamental right of the petitioner under Article 14 and 16 of the Constitution. The record reveals that an affidavit has been filed by the respondent number 2, wherein the stance so taken is that the petitioner was appointed without any sanction post and without the approval of the government. And as such, the petitioner's name, there's a remark against the petitioner's name in the seniority list. First of all, the records further reveal that this court, by an order dated 18/5/2026, directed the director to clarify the position by producing the necessary documents pertaining to the sanction of pertaining to the cadre stand, along with the man in position at the time when the petitioner was appointed, as well as post, as well as and as on date. In pursuance to that, certain instructions have been produced by Mr. Muam Chen, the learned senior government advocate. First, a perusal of the said instructions revealed that at the time when the petitioner was appointed, there were 28 sanction posts to the post of, there's a name again, Sub-Inspector Supply in the Department of Food and Civil Supplies, Nagaland, as on 31/3/2008. The petitioner was appointed by an order dated 30/4/2009 with effect from 1/5/2009. It is also seen from the seniority list so produced that as on 23/3/2010, the petitioner's name featured as serial number 25, meaning thereby the petitioner name was shown against the vacant sanction post. The records further revealed that the petitioner, all this while from 2009 till date, have been paid the regular salary to which a person belonging, a regular salary to what a person who is appointed regularly on as a sub-inspector of supply gets. The question, however, arises as to whether, without an administrative approval, the petitioner's post would have been regularized. Mr. A.G. Momi, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner, that taking into account that for the last 16 years, the petitioner has been serving in the as a sub-inspector of supply, and the petitioner having been paid the salary to which a regular sub-inspector of supply gets, it would be construed to be a deemed approval, administrative approval. Full stop. Full stop. This court have duly taken note of that this administrative approval is to be granted by the PNR department of the government of Nagaland. However, the PNR department is not a party to the present proceedings. In addition to that, the relief sought for in the present proceedings is inadequate for passing an order of deemed administrative approval. The learned counsel, appearing on behalf of the petitioner, therefore submitted that the petitioner would be well advised to withdraw the instant writ petition in view of the revelations which came to light on the basis of production of the documents today before this court. A copy of the documents which have been produced before this court today have also been furnished to Mr. A.G. Momi. The learned counsel therefore submits that the petitioner would like to withdraw the instant writ petition with the liberty to refile. Taking into account the above, the instant writ petition stands closed on withdrawal. Full stop. The withdrawal of the instant writ petition shall not prejudice or preclude the petitioner to again approach this court by removing those formal defects. The instructions which have been placed before this court issued by on the basis of the forwarding communication dated 21/5/2026 by the Director of Food and Civil Supplies is marked with the letter X. So you bring this and we'll have it on Friday. We will move it.
I'll find it next Monday.
Huh?
I'll find it on Monday.
Do it because then only things will move.
Yes, sir.
You have a good case, and you just say that order passed by Justice, the division bench order. I'll give it to him.
Yes,
You have a look at it, and bring some aspects pertaining to Dharam Singh,
Fine.
because Dharam Singh gave it
Yes,
to till then, from that period. So then you will be entitled to the seniority.
I'll do that.